Hi guys, we have put every episode focusing on articles of clerkship and everything that candidate legal practitioners must know before commencing articles into a single episode. So watch this episode for everything you need to know about articles, and you should be hundreds. If you have any questions after this episode, please let us know and we'll happily answer any questions you may have. Enjoy! Let's get into part 1, which is the information and formalities pertaining to articles of clerkship.
What are articles? At university, we are told that we have to complete articles before we can be admitted as an attorney. But what exactly does this mean? Articles, also known as practical vocational training, is a compulsory apprenticeship of sorts for all LLB graduates looking to become attorneys. Candidate attorneys, who are now referred to as candidate legal practitioners, although the titles are interchangeable, either undergo a 2-year contract of articles or a 1-year contract of articles. Regarding the 1-year contract of articles, you will have to successfully complete the full-time program at the School for Legal Practice first. For those students who are still completing the LLB studies, they can either enter into a 5-year contract of articles or a 3-year contract of articles, if you have obtained a 3-year undergraduate degree for the 3-year contract of articles. Most candidates will conclude a 2 years articles contract. What does this mean? This means that the candidate will work for the law firm for a period of 2 years, during which time the candidate will need to attend practical legal training and pass 4 admission exams. Note that candidates were previously required to pass a fit and proper test. However, this is no longer a requirement under the Legal Practice Act. Many candidates will conclude a 1-year contract of articles. After university, I had no clue that this was even an option. Briefly put, when concluding a 1-year contract of articles, the candidate is required to have completed the full-time 6 months School for Legal Practice offered by the Law Society of South Africa. Alternatively, the 1-year long-distance training course offered by UNISA. The available courses will be discussed in a later video. There is also the possibility of entering into a contract of articles for a period of 5 years, alternatively 3 years whilst you are still completing your LLB. This process is slightly more complicated and most candidates do not go this route, so if you are intending on going this route, contact the Legal Practice Council in this regard for more information. Your contract of articles will be entered into between yourself and your principal, which is usually one of the partners or the directors of the firm. They will essentially be your mentor. According to the regulations under Section 109, subsection 1A of the Legal Practice Act, take note that the Attorneys Act has been repealed and replaced with the Legal Practice Act. Under Sub-Regulation 5, a candidate attorney may be engaged or retained under a practical vocational training contract by an attorney practicing for his or her own account, practicing as a partner in a firm of attorneys, practicing as a member of a juristic entity, practicing as a state attorney, who has practiced as a professional assistant in a firm of attorneys for a period of 5 years within the preceding 6 years, or in the full-time employ of, or who is a member of Legal Aid South Africa, a legal aid institution which has been approved by the Council for the purpose of engaging candidate attorneys, any other institution approved by the Council for the purpose of engaging candidate attorneys. Under Sub-Regulation 6, an attorney engaging a candidate attorney, as contemplated in Sub-Regulation 5A to D, must have practiced as an attorney for a period not less than 3 years, or for periods of not less than 3 years in aggregate during the preceding 4 years, and, as contemplated in Sub-Regulation F, must have practiced as an attorney for a period of not less than 3 years, or for periods of not less than 3 years in the aggregate during the preceding 4 years prior to being engaged by Legal Aid South Africa or the institution concerned. Sub-Regulation 7, service by a candidate attorney to any attorney while that attorney is not practicing or has not practiced as provided in Sub-Regulation 5 is not deemed to be service under practical vocational training contract for purposes of these regulations. So, to be safe, just double check that your principal fits any of the above descriptions to ensure that your contract of articles is valid. It's very unlikely that there'll be any issues, but if there are, then you've wasted your time, so it's very important. Articles formalities. Numerous formalities that a candidate legal practitioner must comply with when commencing articles. Compliance with these formalities is imperative. Firstly, you need to submit the following with the LPC within 2 months from the date of your contract. Take note that the LPC refers to the Legal Practice Council, which was formed recently. Previously, the Law Society was the regulatory body for legal practitioners. Okay, firstly, the original signed practical vocational training contract and 2 copies thereof. Check in the description, I've placed a link to a template that you can use. Just click on that and you can complete the template. If you're unable to download the template, you can arrange with the LPC to collect a hard copy or have it posted or sent via DocX. You, your principal, and 2 witnesses must initial each page of the contract and sign same. Secondly, a certified copy of your identity documents, alternatively proof of your date of birth. A certified copy of your LLB degree, alternatively proof of compliance with the requirements for the LLB degree obtained at a South African university. Alternatively, a certified copy of a law degree obtained at a foreign university and certification by SAQA that the degree is equivalent to the LLB degree. Payments of the registration fee in the amount of R345. Please note that this is as of 2021. It is likely to increase. Proof to the satisfaction of the LPC that you are a fit and proper person to serve as a candidate legal practitioner under a practical vocational training contract. This is no longer done by way of a fit and proper test, but rather by submitting 2 written character references not older than 6 months by persons in a position of authority. Next, a written request by the principal that a certificate of right of appearance be issued to the candidate legal practitioner in terms of section 25 subsection 5A or 25 subsection 5B if applicable. Take note that right of appearance will be addressed later in this video series. Next, a certified copy of the report/certificate confirming completion of the program of structured coursework of at least 400 notional hours over a period of not more than 6 months. This is only applicable if you're registering a 1-year contract of articles. Next, you've got the registration application form completed by the principal and the candidate attorney. A link to this form is in the description, so take a look. You can click on the link and you can complete it. If the candidate legal practitioner has a criminal conviction, an affidavit must be submitted setting out the details and sentence. Even if the conviction has been expunged or pardoned, you need to set it out. A copy of the court record is also required. If there are pending criminal charges or disciplinary inquiries against the candidate legal practitioner, an affidavit must be submitted setting out the details. Having a criminal record makes life very difficult for any individual in the legal profession, especially when it comes to being admitted, so be careful out there. Take note that you'll find a link in the description to all the guidelines for registration of a practical vocational training contract, otherwise known as an articles contract. Click on the link, you can see all the guidelines clearly. Just make sure you follow it and comply with that strictly. Further formalities such as admission exams and practical legal training will be discussed throughout the series. As I said at the beginning, I'm not going to cramp everything into one.
And that concludes part 1. You should now know what articles of clerkship are, as well as the formalities involved therewith. That being said, let's have a look at one of the most important formalities that must be complied with, namely practical legal training, or PLT. Alright, what on earth is PLT? When I first started my articles, I had no idea that PLT was even a thing. So what is it? PLT is a compulsory course that all candidate legal practitioners must satisfactorily attend before applying for admission as an attorney. It is imperative to note that there are essentially 2 types of PLT, namely the compulsory course for candidate legal practitioners and the PLT course through the PVT School for Legal Practice. The distinction between the 2 types is important because attendance at the School for Legal Practice will reduce a candidate's required period of articles to 1 year. The other compulsory course does not, and the candidate will still be required to complete a 2-year contract of articles. Regardless, in order to be admitted as an attorney, either one of the PLT courses must be satisfactorily attended by candidates. But let's start with the more common course, which is the ordinary PLT course for candidates completing a 2-year contract of articles. We will distinguish between the two by referring to the compulsory course and the school for legal practice. Okay, first things first, the compulsory course. Introduction and purpose. All candidates completing a 2-year contract of articles must satisfactorily attend this compulsory course. As was the case in the first episode, for those candidates undergoing 3 or 5-year articles, make sure to consult the LPC regarding PLT. The course is presented via lectures, classes, the purpose thereof being to prepare candidates for each of the 4 admission exams. Module 1 is designed to assist candidates to prepare for the first paper, and Module 2 for the second, third, and fourth papers. For your information, the 4 admission exams are as follows. Paper 1, High Court Procedure, Magistrates Court Procedure, Personal Injury Claims, and Criminal Procedure. Paper 2, Administration of Deceased Estate, Drafting of Wills, and Succession. Paper 3, Practice, Duties, Ethics, and Functions of a Legal Practitioner. Paper 4, Legal Practitioner's Accounts Management, or Legal Accounting, also known as Bookkeeping. When do I attend the compulsory course? The compulsory course is presented on a full-time, part-time, and evening basis. The full-time course? It takes place over 23 days, split in 2 sessions over the year, from 8 until 4 p.m. Paper 1 preparation takes place during the first semester, and preparation for the remaining papers takes place during the second semester. The part-time course? The part-time course will, as far as possible, be presented on 1 full day per week over a period of approximately 5 months from 8 until 4. The advantage of the part-time course is that candidate legal practitioners are not absent from the office for extended, continuous periods. The evening course? The course is presented on 2 evenings per week over a period of 5 months. On these evenings, class will be from 5:30 to 9 p.m. But don't stress, class doesn't always go until 9 p.m. The bookkeeping classes, which are paper 4, will be presented over 1 full week, but this will be communicated to you. Evening 1A is presented on Monday and Wednesday evenings, and Evening 1B is presented on Tuesday and Thursday evenings. You will be advised which evening you fall under once you are registered for the course. Should you be unable to attend class for whatever reason, you'll be marked as absent. This includes sickness, family responsibility leave, or duty at your firm. It is imperative that you arrange to attend a catch-up class. Catch-up classes can be arranged at a cost of R200 per class. Contact the course coordinator for more information in this regard. Attendance is taken at every single class, and it is advisable that you take a photograph of the attendance registry at each class confirming your attendance for that particular date. If you do not have a 100% course attendance, you may encounter difficulties being admitted as an attorney. Take note of ex parte postma, where the judge commented on satisfactory attendance. He said the applicant was absent for 4 out of the 20 days of the course. This is definitely not satisfactory attendance. Where are classes presented? Depending on where you are in South Africa, the course is presented at the following venues: the University of the Witwatersrand in Johannesburg, UNISA in Pretoria, the University of Pretoria in Pretoria, the University of KwaZulu-Natal in Durban and Pietermaritzburg, the University of the Northwest in Potchefstroom, the University of the Free State in Bloemfontein, Nelson Mandela University in Port Elizabeth, and the Wahlberg Conference Centre in Cape Town. Take note that the dress code is informal but neat. Most candidates will be coming straight from work, so that should not be an issue. You must also note that you're required to make your own arrangements to get to and from classes. Subjects and course content. Classes are presented as lectures, with a different lecturer for most subjects. The lecturers are usually practicing attorneys. The course is presented in English. Module 1 consists of the following subjects: constitutional practice, high court practice, magistrates court practice, criminal court practice, personal injury claims, which is blended learning, and professional legal ethics. Module 2 involves the following subjects: wills and estates, drafting of contracts, matrimonial law, which is blended learning as well, labor dispute resolution, alternative dispute resolution, information and communications technology for practice and associated aspects of cyber law, which is online, insolvency practice, which is blended learning, numeracy skills, which is offered online, including attendance for those who fail the online assessment, introduction to practice management, which is offered online, legal costs, and legal practitioners accounts management, also known as legal bookkeeping, and value-added tax, which is obviously VAT. Fees and registration. As of 2021, the full-time course costs R4,615 for registered candidate legal practitioners and R5,670 for non-registered candidates. The part-time and evening course costs R4,615 for registered candidate legal practitioners and R5,670 for non-registered candidate legal practitioners. Each candidate must register for the course individually. Check out the link in the description where you can actually register for the course. This link might only be available for 2021, so just make sure. Payment must be made by electronic funds transfer, which is an EFT, and proof of payment must be uploaded in PDF format in step 2 on the online registration form. Once you have successfully registered, you will receive an email confirmation. Take note that no meals or drinks are provided. The School for Legal Practice. Introduction and Purpose. The School for Legal Practice, also known as the PVT School, provides a postgraduate vocational training course for law graduates. LLB graduates who successfully complete the course qualify to reduce their PVT or articles contract period by 12 months should they wish to be registered as attorneys. There are a limited number of places available at each campus, and applicants go through a selection process before being accepted, so your acceptance is not guaranteed. If you are accepted, you will receive a letter of acceptance. PVT School provides practical training to candidates and prepares them for the admission exams. When do I attend the School for Legal Practice? The course takes place over 6 months. Depending on the campus, the course is offered during the day and/or after hours. The after hours classes are intended to assist individuals working during the day. Day school takes place from Monday to Friday from 8:15 until 4 and certain Saturdays from 8:30 until 1:30. Night school takes place from Monday to Friday from 5 until 10 and certain Saturdays from 8:30 until 1:30. Full attendance is required to complete the PVT school successfully. As already mentioned regarding the compulsory course, satisfactory attendance is crucial. Where are the classes presented? PVT school is presented at 9 different venues around the country. They are as follows: Bloemfontein, Palm Park, Cape Town, Berghouse, Durban, UKZN, East London, 6 Donald Road, Johannesburg, Richmond Forum 1, Polokwane, Edu Park, Port Elizabeth, NMMU, Potchefstroom, Northwest University, Pretoria, UNISA, and the LSSA/UNISA Distance School is at UNISA in Pretoria. For more information on the venues, as well as various contact details, check out the link in the description. Subjects and course content. Training is practice-orientated to ensure that candidates will be able to perform most tasks on an entry level with minimal supervision once they have completed the course. Candidates are trained in a simulated law firm environment. Each candidate is allocated to a law firm. Each law firm has access to an office, and candidates have access to computers and a law library. Moot court and practical work form the foundation of the training activities. Candidates exchange pleadings and draft the necessary court papers in action and application proceedings. The PVT school comprises of the following modules consisting of 400 notional hours in total: alternative dispute resolution, attorney's bookkeeping, constitutional practice, criminal court practice, drafting of contracts, high court practice, information and communication technology for practice and associated aspects of cyber law, introduction to practice management, labor dispute resolution, legal costs, magistrates court practice, matrimonial law, personal injury claims, professional legal ethics, and wills and estates. Take note that classes are presented in English. Formative and summative assessments will be conducted. A minimum of 50% per summative assessment and full attendance is required to complete the program successfully. For the UNISA distance school, a minimum of 50% per summative assessment and 130 hours of participation is required to complete the program successfully. Fees and registration. The estimated tuition fee is 15,150 Rand VAT included as of 2021. If your application is successful, payment of the fee must be done before the course commences. The fee includes study material but excludes stationery. Students are responsible for their own arrangements and expenses regarding accommodation and traveling. To register for the PVT school, check out the link in the description. So now you know what practical legal training is, but what about the admission exams? Let's get into that in part 3 of this episode. As mentioned in the previous episode, the 4 admission exams are as follows. Paper 1, High Court Procedure, Magistrates Court Procedure, Personal Injury Claims, and Criminal Procedure. Paper 2 is the Administration of Deceased Estates, Drafting of Wills, and Succession. Paper 3 contains the practice, duties, ethics, and functions of a legal practitioner. Paper 4 is the legal practitioner's accounts management, also known as legal accounting, or more commonly known amongst candidates as bookkeeping. Before we get into the papers, let's answer some of the general questions which a candidate may have regarding the admission exams. Are the exams compulsory? Absolutely. Passing each of the 4 admission exams is a prerequisite to being admitted as an attorney, so they are definitely compulsory. When must I write the exams? Candidates will write the admission exams during the contract of articles. The admission exams can be written twice a year. Candidates can normally write in February and or August of each year. The exams are written over 2 consecutive days. Paper 1 and Paper 2 are written on the first day, and Paper 3 and Paper 4 on the second day. For 2021, the first period to write was held on 17 and 18 March 2021. The next exam dates are 17 and 18 August 2021. To be specific, Paper 1 and 2 will be written on 17 August 2021, and Paper 2 and 3 will be written on 18 August 2021. Can I just pitch up and write the exams? No, you need to register to be able to write the exams. To register, you must contact the applicable LPC officers. You'll see below that I've put all their emails and contact details there. Just click on or send an email to the office that applies to you, and you can go from there. Registration forms can also be found on the LPC website. The deadline for registration is usually around 3 weeks prior to the particular exam date, but make sure to confirm this with the LPC. Must I write all 4 exams at once? No, you may write your exams in different exam periods. You will, however, want to complete all 4 exams within your articles period, as you cannot be admitted without passing the exams. You could potentially write 2 exams in the first exam writing period, for example, February, and the remaining 2 6 months later in the second exam period, which will probably be, August. If you really wanted to, you could write 1 exam at a time, but this is not recommended. You can, of course, as many brave individuals do, write all 4 exams at once over the 2 days. Just bear in mind that if you fail any exam, and if you get an oral and fail the oral, you'll have to rewrite that particular exam during the next exam period, which, as we've already discussed, will be around 6 months later. No, a candidate may complete the 4 papers of the examination in any sequence. You could write Paper 3 and 4 in August 2021, and Paper 1 and 2 in February 2022, or Paper 1 in August 2021, and the remaining papers in February 2022, and so on. You get what I'm saying. What must be considered on the day of writing? Candidates should report for the examination at least 30 minutes prior to the commencement thereof. Candidates are required to, on the day of the examination, properly identify themselves by providing the identity document or passport. No candidate will be permitted to write any examination if satisfactory proof of identity is not proved. No candidate will be allowed to enter the examination 30 minutes after the commencement of the examination, and no candidate will be permitted to leave the examination venue within 30 minutes of commencement of the examination. After conclusion of the examination, and when handing in the examination book, each candidate must sign the register for the paper written. What do I need to get to pass the admission exams? A candidate who attains 50% or more in a paper will be deemed to have passed, and subject to special circumstances, a candidate may have to attend an oral. Candidates who achieve between 40% and 49% in any of the papers will be permitted to do an oral in respect to that paper. Candidates who attain less than 40% in any of these papers will be deemed to have failed the paper and will not be given an oral. The candidate will have to rewrite the exam during the next exam period. Candidates who are dissatisfied with their marks in any section of the examination may have their paper remarked before orals are conducted if they apply in writing for a remark to the LPC within 1 week of the results of the exam becoming available. They pay a remark fee equivalent to twice the fee payable for the section of the examination in which the remark is requested. If the remark is successful in that the status improves, for example, you failed and after the remark you qualify for an oral, this fee will be refunded. Take note that if you fail an exam, it is only the exam that you failed that will have to be rewritten. So if you write, for example, paper 1 and 3 in an exam period and you pass paper 1 but fail paper 3, you will only have to rewrite paper 3. What happens if I qualify for an oral exam? Candidates who have to present themselves for oral examinations will be tested on their verbal presentation of legal knowledge. Oral exams usually take place at certain law firms and are conducted by a few directors of the specific firm to which the candidate is allocated. Oral exams can be tough in the sense that you'll need to think on your feet as the examination takes place orally in a boardroom. Do not be intimidated by the examiners. They are ordinary people just like us. Treat the oral as an interview, I would say. The actual exam is quick. You only get asked a few questions and you would be advised whether you passed or failed immediately. Or at least from my experience, that was the case. It's very difficult to say what you will be asked in the oral exam, but you can generally be asked anything that would be asked in the written exam. You could also be asked questions not included in the written exam, so you'll need to study everything. Consider going through your paper to see where you think you went wrong. Who prepares the exam papers? Examiners and experts in the various fields set the papers. Moderators, appointed from the ranks of the examiners, check, discuss, and approve these papers and review the marked papers to ensure quality assurance and reasonableness of the marks allocated. How should I prepare for the exams? Past paper after past paper after past paper. Do not only do past papers though, also go through the study material. The past papers will give you an idea of how questions are asked. Copies of previous papers and answer guides are available from the Legal Education and Development, or the LEAD website, for free to download. I only have certain past papers that I could find on record, so I've actually created a Google Drive and I've put the past papers in there. You're welcome to access it. I'll put the link in the description below. I really wish I had more past papers for you guys. Each exam will be discussed shortly, where I will provide further tips on studying for the exams. What can I expect in each exam paper? According to the Law Society of South Africa's website, candidates are allowed 15 minutes to peruse the paper before starting to answer the questions. No candidate may start writing an answer book during this period. This is the case with each admission exam. In a single question, candidates may be tested on their knowledge of the rules and practice in the courts in whose jurisdiction they are examined, and simultaneously, they may be tested on their ability to examine and analyze facts placed before them, to apply the substantive law to the facts, and to draft documents logically and coherently based on the facts that are relevant. Candidates must have a general understanding of the role of a legal practitioner and an officer of the court, of the role of the legal profession in society, of the ethics of the profession, and an ability to recognize conflicts of interest and ethical difficulties. Candidates will be required to know the rules of the Legal Practice Council in as far as they relate to professional conduct. Candidates must be competent and have adequate experience in the basic skills and techniques of legal practitioners, and for that purpose, be able to handle facts and apply legal principles to factual situations, be able to research legal problems and to use the sources of law, have knowledge of the practical aspects of advocacy, in brackets the arguing of elementary cases before courts and tribunals and the effective presentation of written legal arguments, which shall include knowledge of negotiation, for example, to settle the terms of an agreement, out-of-court settlements, finalizing disputes without recourse to the courts, the preparation for and the conduct of a trial in the High Court, the Magistrates' Court and other tribunals, the gathering and preparation of evidence and the procedures relating to the calling of witnesses in civil and criminal courts. They must understand office procedures and routines, including the keeping of legal practitioners' books and the preparation and rendering of bills of costs and accounts, and administer the affairs of clients. They must be experienced in the drafting of documents, could be straightforward contracts, wills, pleadings, opinions, briefs to counsel, and in particular pleadings in the Magistrates' Court, and where relevant in the High Court. They must be able to communicate effectively with clients, colleagues, and officials orally and in writing. Apart from the other relevant acts already mentioned above, the undermentioned additional acts, as amended, including rules and regulations where applicable, are relevant in all papers, but particularly in legal practitioners' practice, which is Paper 3. These acts are the Apportionment of Damages Act, Justices of the Peace and Commissioners of Oath Act, National Credit Act, Conventional Penalties Act, Trust Property Control Act, Prescription Act, Legal Practice Act, Insolvency Act, Divorce Act, Matrimonial Property Act, Maintenance Act, Constitution Act, such as the Constitution, Consumer Protection Act, and the Prevention of Illegal Eviction and Unlawful Occupation of Land Act, which is PI, Basic Conditions of Employment Act, and the Legal Practice Act. Although the emphasis in the examination is on practical aspects and the candidate's understanding of the substantive law and its practical application in practice, this can never be totally separated from a thorough knowledge of the law, the acts and the regulations and the rules of court. The allocation of marks is a good indication of the detail required. Candidates should, in the examinations, consider the question paper and plan for each section accordingly. Unless informed to the contrary, all questions should be answered with reference to current legislation, regulations, rules, etc. Now that all of that is out of the way, let's get into each exam paper. Paper 1. As mentioned above, Paper 1 contains questions on High Court procedure, Magistrates' Court procedure, personal injury claims, and criminal procedure. The paper itself is 3 hours and is out of 100 marks. Candidates will have an additional 15 minutes at the beginning of the exam to read through the paper. No writing is allowed during this time. The paper is written on the first day of the examinations, usually in the morning session, approximately from 9. Paper 1 and 3 are usually the most demanding in terms of content that a candidate will need to learn, as the papers cover a wide range of subjects. Paper 1 generally consists of a mix of drafting and theory. With regards to the High Court, the practical application of the High Court Act and the rules must be known. There will be drafting in this respect, which will be notices of motion, affidavits, and causes of action for a summons, and other notices and documents in respect of which no prescribed form exists. You'll have to draft instructions to counsel and pleadings and letters and opinions. With regards to the Magistrates' Court, you'll also have to know the Magistrates' Courts Act and rules. Again, you'll be required to draft the same documents as you would be for the High Court. Then we have motor vehicle accidents. You should know all the aspects of the Multilateral Motor Vehicle Accidents Fund as amended, as well as the Road Accident Fund Act, the regulations promulgated in terms of this act, as well as the case law concerning the rights of injured persons and dependents, and the procedure relating to the formulation, computation, and institution of claims against the fund. Make sure that you're aware of any legislative changes as and when they become in operation. Questions relating thereto may be included in the exam papers. Regarding criminal procedure, no aspects regarding the role of the prosecutor, investigation of crime, and the various methods to secure the accused's attendance in court. The procedure relating to a criminal trial, including applications for bail, the procuring of evidence, and a general working knowledge of the Criminal Procedure Act. Pay special attention to the following sections of the Criminal Procedure Act. You'll see them on the YouTube video. Make sure you know those sections. I found for paper 1, the best way of preparing for this paper in particular is doing 1,000,000 past papers. Drafting is also crucial. Make sure you know how to draft, but if you've been a candidate for some time, you should have some experience in drafting. Make sure you know that. Paper 2. This involves the administration of deceased estates, the drafting of wills, and the law of succession. This paper is written on the first day of the examinations, usually in the afternoon session, approximately from 2. This paper is set as a 1.5-hour paper, but 2 hours are allowed for completing it to allow candidates to read the questions carefully before answering them. The paper counts 100 marks. You must be able to do the following, amongst other things. With regards to drafting, there will be estate accounts, wills, and testamentary trusts. And with regards to theory, a general working knowledge of the Administration of Estates Act and its regulations, the execution of wills process, the application of the law of testate and intestate succession, the principles of estate duty and capital gains tax relating to deceased estates, and a rudimentary knowledge of estate planning. Paper 2 initially showed me flames when I wrote it. I actually got an oral for it and managed to pass the oral, but knowing how to draft the estate account is a very difficult thing. But once you got it, it's quite easy, but it can be a very tricky paper. I do suggest for preparing with this paper, as well as paper 4, which is the attorney's bookkeeping, I would suggest you attend Johan van Ack's revision classes. For more information on his classes, you can send an email to johan@vanack.org.za. I'm not going to put more of his details on here. I just don't want to, leave him vulnerable in the open. So you can just contact him. I think the course takes place over a week or so if you do both. There's evening classes, and then there's a full weekend. I would highly suggest this. Even if you don't do Van Ack's classes, there are many people offering revision classes for these two subjects in particular. So I would definitely make sure to attend that because it really does help. Right, paper 3. This paper involves the practice, duties, ethics, and functions of a legal practitioner. This paper is written on the second day of the examinations in the morning session, approximately from 9. It is a 1.5-hour paper as well, but 2 hours are allowed for completing it to allow candidates to read the questions carefully before answering them. The paper counts 100 marks. Professional ethics feature very prominently in this section. This means all the rules of the professional conduct as appertaining to a legal practitioner's professional life, as an officer of the court, in his relationship with his clients, colleagues, and his staff, also extra-professionally while he remains in the profession. The second broad subject that is included in this section is the drafting of the following documents: deeds of sale for both movable and immovable goods, partnership agreements, suretyship, acknowledgements of debt, cession and assignment, option and right of preemption, sale of business, lease of fixed property, letter of demand, pledge, cancellation of agreements, and an indemnity. The paper on general practice does not stand in complete isolation to the content of other papers in the examination. For example, a question on ethics may relate to a situation arising during litigation, and the legal opinion may be one relating to magistrates' court procedures, for example. Finally, the purpose of the paper is to cover subjects or topics that do not strictly belong to any other sections in which the examination is conducted, but are very important in a legal practitioner's practice. The following are prescribed acts and regulations that could be referenced in the paper. Take note: the Legal Practice Act, Prescription Act, the Alienation of Land Act, Matrimonial Property Act, Insolvency Act, Companies Act, Trust Property Control Act, Justice of the Peace and Commissioners of Oath Act, Contingency Fees Act, National Credit Act, Consumer Protection Act, Labor Relations Act. Make sure you also, where to the extent that these acts have been amended, you know the amendments. Just be reminded that the exam, study material, and criteria can change, so do not strictly rely on this information found here. The Law Society or the LPC is very good with giving an exam criteria. This paper requires a lot of study. It's a difficult paper. So also the questions can be quite ambiguous. So past papers and the answer booklets are quite crucial. Paper 4. Then have the final exam, which is paper 4, which involves legal practitioners' accounts management, which is legal accounting. This exam is also known as bookkeeping. This paper is written on the second day of the examinations in the afternoon session, approximately from 2. This paper set is a 1.5 hour paper, but 2 hours are allowed for completing it. The paper counts 100 marks. This entails a test in respect of the practical skills necessary for the keeping of legal practitioners' books of accounts. Candidates must show a thorough knowledge of the concept of trust money and of the essential requirements of the modern double-entry bookkeeping system as applied to legal practitioners' bookkeeping, the functions of the various books of accounts, and must have sufficient practical knowledge of the supervising of bookkeeping to enable them to maintain the books of account required in a legal practitioner's office. They must be able to apply accepted measures, controls, and ethical standards to bookkeeping and financial matters. Questions on that may be included in this paper. Take note that no bookkeeping paper will be provided in the answer books. You will have to draw up the necessary columns for the various books of account required. You may also bring a calculator for this paper. Do not forget your calculator. If you're not good with numbers or accounting like I am, you will find this exam tricky. Once you understand how to do it, it's simple, but it's getting to that understanding. So I would highly suggest Finax classes or any other revision classes. It really is a tricky one if you don't know what you're doing. If you do, it's a breeze. Okay. Now that we've got some of the formalities out of the way, let's look at what your job as a candidate legal practitioner will actually entail, as well as the salary you can expect. What will my job as a candidate legal practitioner likely entail? Your job may differ depending on the type and size of the firm. For example, the bigger firms are more structured, so candidates are often rotated from departments to experience different fields of law. Generally, however, most candidates can expect to do the following, amongst a wide variety of other things. Take note that if you are doing your articles in a firm that specializes in a certain field, this may not apply to you as much. For example, if you're dealing with mergers and acquisitions, or strictly employment law, or strictly contract drafting, you will probably find that driving, etc., will not apply to you to such an extent. However, to most candidates, the following will be part of your day-to-day tasks. Driving. You'll be driving to court. You'll be driving to court for purposes of issuing processes, filing notices and pleadings, and appearing in front of magistrates. You will likely also accompany counsel and other attorneys in your firm when they appear before a presiding officer. You may also be required to deliver documents to the master's office and the deeds office and any surrounding offices in the area. Candidates in the bigger firms will unlikely have to drive for purposes of issuing, serving, and delivering, as their court messengers normally attend to this. Small firms also tend to employ messengers, but not as many as the bigger firms, so candidates will very likely be required to drive. To sheriffs. You'll be delivering pleadings and notices to sheriff's officers for purposes of having the sheriff serve same on the opposition. You'll also be collecting returns of services and the original pleadings and notices from the officers subsequent to service taking place. You could also potentially attend a sale and execution at the sheriff's offices to protect your client's interests. Each sheriff's office covers a particular jurisdiction, so there are many sheriffs in many different areas. To other attorneys' offices, you'll be attending many attorneys' offices for purposes of serving notices and pleadings. When attorneys come on record for a party, you no longer instruct the sheriff to serve pleadings and notices on the opposition, as you could simply serve directly on the attorney instead. These days, most attorneys consent to service via email, so hopefully you'll not need to drive too much in this regard. To counsel. Advocates are commonly referred to as counsel. You'll be required to deliver briefs, which are instructions, to your counsel's chambers, which are their offices. You'll also conduct meetings and consults at counsel's chambers. Due to COVID, counsels often brief via email, and meetings and consults often take place virtually, so your driving in this regard will be substantially less than usual. For those in criminal law, you will find yourself driving to courts, to police stations, and so on, perhaps to the accused's place of residence and all of that. It must be noted, however, that law firms may no longer require as a prerequisite when advertising job posts for candidates that the candidate have a driver's license or their own vehicle. If you do not have a driver's license, you will obviously not have to drive. Whether a firm will actually employ a candidate without a driver's license is uncertain. Most firms have their own company vehicles, but in the event that they do not, the candidate should be able to claim back petrol and other expenses from the firm. Court attendances, admin. Issuing court processes. All new summonses and applications must be issued. Issuing entails the allocation of a case number and the opening of a file. This is done by the registrar in the High Court and the Regional Court, or the clerk of the court, which is done in the Magistrates' Court. Filing. Whenever a pleading or notice is served, it needs to be filed as soon as possible thereafter. Filing entails going to court with said pleading or notice, together with proof of service thereof, and having it stamped by the registrar or the clerk, depending on which court you are in. You can physically file the notice or pleading by leaving the original in the court file after having same stamped, or you can have it stamped and returned to the office with it. Before a matter is heard, you'll be required to compile an indexed and paginated bundle, which will contain all the relevant served and filed pleadings. In the Johannesburg and Pretoria High Courts, you will file notices and pleadings by uploading them to case lines. These courts are mostly online now. Information on the case line system will have to be an entire episode on its own because it's extremely complicated, but it's been such a blessing. Magistrates' courts are so disorganized that we doubt they will ever be online. Accompanying counsel or senior attorneys to court for matters. Counsel and senior attorneys may require your assistance in court when they are arguing matters. You'll not be expected to do much, but it's very beneficial to watch and understand how court appearances take place. You should take notes of anything important said by the magistrate or judge, as well as either party's representative. Again, in Joburg and Pretoria High Court, arguments is mostly done via MS Teams, which you can just log onto after receiving the hearing link. Some judges do, however, direct that matters be heard in open court, in which event you'll need to physically attend court. Yes! Court appearances. Section 65 Financial Inquiries. Every candidate will get to experience the joys of a Section 65 financial inquiry. These inquiries take place in the Magistrates' Court after judgment has been granted against the defendants. Take note that there's no Section 65s in the High Court. Section 65 hearings are in essence an inquiry into the financial position of the judgment debtor. In the hearing, the judgment debtor, under oath, presents oral evidence as to their financial position. The court will then make an order with regards to the repayment of the judgment debt and associated costs. You will also be doing Section 65J hearings, which are emolument attachment orders, but we'll be discussing Section 65 inquiries and all of that in much greater detail in an episode still to be released. Default judgments. In certain magistrates' courts, default judgments are lodged with the clerk of the court, and as a result, no argument is required. The magistrate will consider the default judgment request on the papers. In other magistrates' courts, the default judgment application will be heard in open court, where you will be required to appear. Also, if you have your right of appearance in the regional court, you may be required to move a default judgment application in said court. Remember, right of appearance in the regional court you will get after 1 year of doing your articles. These applications are generally very straightforward, but we'll also discuss same in much more depth in a later episode. Unopposed motions. Moving an unopposed motion is relatively simple. As no opposing papers would have been received, the candidate will simply need to understand the matter and the law behind it in case the magistrate asks questions. Of course, some unopposed motions can be reasonably tricky, but we are speaking generally here. In certain unopposed motions, but like I said, we'll touch on in a later episode, you can receive opposing papers and still proceed on an unopposed basis, but we'll discuss it at a later time. Regarding criminal law, we don't personally do much of that. However, you will very likely be attending to bail hearings and similar applications. Drafting. You'll be expected to draft simple pleadings and notices, and as you progress, more complicated pleadings and notices. You'll also be drafting letters, sheriff instructions, and emails. Use past examples of the relevant notice or pleading as a template to start. So if someone in your firm has already drafted a notice of bar, for example, use that notice of bar and just change the details on it so you can learn how to start doing it yourself. More complicated notices and pleadings, you will obviously not be able to simply just change the party's details. You will need to do your own work as well. Mundane tasks. You can expect to do plenty of printing, filing, copying and pagination, opening and maintenance of files, closing of files, and sending of invoices. You'll also be diarizing files. This is a necessary but probably the least enjoyable aspect of articles. It really is time consuming and boring, but it's what you got to go through. Meetings. You will accompany your principal and other attorneys to meetings with counsel, clients, and opposition. As you progress, you will start attending meetings without your principal. When you accompany counsel and senior attorneys to meetings, take notes of the discussion. Research. Research is always required, so you'll regularly be researching legislation, case law, common law, and so on. You may also be required to draft opinions based on the research you have conducted. Whilst being a candidate, the opinions will mostly be for your principal as opposed to clients, because you are still learning. Take note that research doesn't stop once you become admitted. We are constantly researching as attorneys. Taking and making telephone calls. You'll have regular telephonic conversations with clients, debtors, sheriffs, attorneys, and so on. Writing fees. You may be required to record fees for your principal.
Yes!
Take note that what has been mentioned herein about court appearances, etc., is only a brief outline. We will be releasing further episodes later on down the line where we will address in depth, for example, Section 65s and default judgments. If we did that all in this video, it would be a 4-hour video. What advice would you give me as a candidate legal practitioner? If we had to give candidates advice based on personal experience, it would be the following. Carry a pen and notepad at all times. You'll be learning new things so frequently that you'll need to write it all down. Whether it's the procedure to issue a summons at court or how to draft a pleading, take notes. You'll be grateful that you did. Have a proper diary. Make sure to diarize all your tasks and deadlines, as you'll not be able to remember them off the top of your head. Don't be scared to ask questions. Your principal was once a candidate legal practitioner too. We know that you're still learning and asking questions is encouraged. We would much rather you ask questions than sitting doing nothing because you don't know what to do. Before asking questions, try to figure out how to do the task. Your principal will appreciate seeing evidence that you first attempted the task before coming with questions. If the answer to your question could potentially be found in legislation, rules, or case law, make sure to consult those sources first. Let's take prescription for example. Your principal instructs you to determine whether a claim is prescribed. Your first source would be the Prescription Act, and after perusing same, you'll be able to establish the prescription period. You could then have to determine whether prescription was interrupted for any reason. Should you struggle to grasp the concept of interruption, show your principal that you have ascertained the prescription period as well as the scenarios which would interrupt prescription. Your principal would then explain, based on your research, where the prescription was interrupted and why. Attend to instructions as soon as possible. When your principal asks you to do something, if possible, drop what you're doing and attend to the task. If you can't attend to the task immediately, communicate this with your principal. If the task is taking you longer than expected, inform your principal. Communication is key.
Yes! Yes!
Move promptly when your principal calls you into the office. Essentially, do what your principal says within reason, as you want to give off a good impression. Work as many hours as may be necessary. Strictly speaking, office hours are usually from around 8 a.m. to 5 p.m. However, this does not apply to candidates, and in fact, the legal profession as a whole. Candidates are expected to work as many hours as it takes to meet deadlines. You'll very likely find yourself working on evenings and weekends. The extra effort you put in will certainly be noticed. Think of articles like boot camp in the army. You go through hell to be adequately prepared for the real deal. At the end of the day, you're aiming to have your firm retain you as an attorney upon completion of articles. So make sure you give them a reason to do so. Read law books in your spare time. We would highly recommend the following books: Amler's Precedents of Pleadings, the latest edition, Eckhard's Principles of Civil Procedure in the Magistrates Court, and The Survivor's Guide for Candidate Attorneys. Should your firm specialize in a particular field, constantly read up on that field. Read books, read articles, respect deadlines. If your principal gives you a deadline, meet it. If you have to work into the evening and on your weekends, do it. We've already mentioned this. Be prepared. Whatever you may be doing, whether it be a court appearance or a meeting, make sure you are prepared and know what you're talking about. Think about what kind of questions you could be asked so that you already know how to answer them. Solid communication. As has been made evident above, communication is so important. If there is no chance that you could meet any particular deadline, despite working late, communicate this with your principal clearly instead of simply not meeting the deadline. Remember that you're still learning, so do not make the mistake of not knowing how to communicate effectively. It's really important. Don't panic. If you don't know the answer to something, don't panic and answer with "I don't know." Say you need to confirm this, or I need to obtain instructions from my clients in this regard. Research is imperative. You'll be doing research of some kind almost daily. Figure out what method of research works best for you. Most case law, legislation, and rules can be found online. Even better are law textbooks and commentary, of which your firm should have plenty. It is unfortunately not uncommon to have an awful principal. If this is the case, perhaps try and stick it out. But if the relationship or work environment becomes too toxic, you may want to consider ceding your articles. We will be discussing ceding of articles in a later episode. Your salary as a candidate legal practitioner. From what we have established from chatting to colleagues in the legal profession, your salary as a candidate will likely differ depending on the size and notoriety of the law firm at which you are completing your articles. Candidates at predominantly small firms, I hate to break it to you, but your salary will very likely be dismal. This is not the case at every small firm, but you should expect between 4,000 to 12,000 Rand per month as a starting salary. We have, however, heard horror stories of candidates getting paid as little as 1,500 Rand per month. That kind of salary is beyond exploitation. Candidates must, however, bear in mind that they are essentially interns, and as a result, a low salary should be expected, to an extent, not 1,500 Rand. So we're not necessarily saying it's justified, but it's unfortunately the current consensus among small firms. Should you be employed by a medium to large size firm, you can expect a salary of anywhere between 11,000 to 25,000 Rand. Again, this is not the case with all bigger firms, as there's no set rule as to what candidates should be paid. You could find yourself at a reputable law firm earning less than 10,000 Rand, or more than 25,000 Rand. Upon admission, you should see a reasonable jump in salary. However, being an attorney is not this lavish job that will put you into the top bracket of the richest people in the world, at least not immediately. As a rough estimate, newly admitted attorneys in small firms can expect anywhere between 10,000 Rand to 30,000 Rand as a starting salary. In the bigger firms, you can expect between 20,000 Rand to 45,000 Rand. As usual, there are exceptions to this, but if you are a newly admitted attorney being paid less than 10,000 Rand per month, I would assess my options. Over time, most attorneys should be able to live comfortably with the salary they are paid. But to be really well off, you will need to be in a high position in your firm with a decent amount of experience behind you. It also appears that corporate, where for example you could be a legal advisor and not a practicing attorney, pays a lot more than law firms. Again, this is not always the case. It's situational. You can be at a law firm making a lot more money than a legal advisor at a corporate. Okay, so you've been through hell, you've met all the requirements, complied with all the formalities, and now it's your time to be admitted as an attorney. Let's get into this procedure. How do I get admitted as an attorney? Remember, to be admitted, the following requirements must be met. Candidates must have the requisite degree. They must serve under a contract of articles, also known as practical vocational training contract. They must complete the compulsory practical legal training, and they have to pass the 4 admission exams. Should your contract of articles be coming to an end, and you have satisfied all the other requirements, you'll be in a position to begin the process of applying for admission as an attorney. Remember, this channel only focuses on attorneys and not advocates. Sorry about that. The Legal Practice Act, together with the rules and the regulations thereof, dictate the admission procedure. Previously, it was the Attorneys Act that did so. However, said act has been repealed. Firstly, Rule 17.1 states that a person seeking to be admitted to practice and be authorized to be enrolled as an attorney under the Act must apply to a High Court in terms of the provisions of Section 24, subsection 2 of the Act, and must simultaneously lodge an application in terms of Section 30, subsection 1a, and Section 30, subsection b3 of the Act with the Council, through the Provincial Council where the applicant intends to practice, or in the case of a person who does not intend to practice, where that person is ordinarily resident, for the enrolment of his or her name on the roll of attorneys or on the roll of non-practicing attorneys as the case may be, which application shall be treated as an application subject to the condition that the applicant is duly admitted by the High Court and authorized to be enrolled as a legal practitioner in terms of Section 30 of the Act. Section 24, subsection 2 of the LPA states, the High Court must admit to practice and authorize to be enrolled as a legal practitioner, conveyancer, or notary any person who, upon application, satisfies the court that he or she is a duly qualified person as set out in Section 26, b, is a South African citizen or permanent resident in the Republic, c, is a fit and proper person to be so admitted, and d, has served a copy of the application on the Council containing the information as determined in the rules within the time period determined in the rules. Section 30, subsection 1a states that a person duly admitted by the High Court and authorized to be enrolled to practice as a legal practitioner must apply to the Council in the manner determined in the rules for the enrollment of his or her name on the roll. Section 30, subsection 1b3 states the application referred to in paragraph A must be submitted to the Council in the manner determined in the rules through the Provincial Council where the legal practitioner intends to practice. Take note, a link to the enrollment form has been placed in the video description below. Section 26, subsection 1 of the LPA states that, just note that this is paraphrased, a person qualifies to be admitted and enrolled as a legal practitioner if that person has a, satisfied all the requirements for the LLB degree obtained at any university registered in the Republic after pursuing for that degree a course of study of not less than 4 years, or a course of study of not less than 5 years if the LLB degree is preceded by a bachelor's degree other than the LLB degree as determined in the rules of the university in question and approved by the Council, or subject to Section 24, subsection 2b, satisfied all the requirements for a law degree obtained in a foreign country, which is equivalent to the LLB degree and recognized by the South African Qualifications Authority established by the National Qualifications Framework Act, and undergone all the practical vocational training requirements as a candidate legal practitioner prescribed by the Minister, including community service as contemplated in Section 29, and a legal practice management training course for candidate legal practitioners who intend to practice as attorneys referred to in Section 34, subsection 2b, and passed a competency-based examination or assessment for candidate legal practitioners as may be determined in the rules. We would advise that you begin drafting your admission application and compiling the relevant annexures in advance, as you don't want to delay being admitted as an attorney due to error on your part. In other words, don't wait until you've served your entire period of articles before you start drafting. Note, however, that you may only post the founding affidavit once the articles period you are obliged to serve has been served. A link to the Legal Practice Act, its rules and its regulations can be found in the video description below. Okay, enough of the boring stuff, let's get into it. What must be included in my admission application? Your admission application will consist of the application itself, the founding affidavit, as well as the annexures thereto. There are many. We'll start with the application itself, which you should know by now is a notice of motion. The notice of motion, it must be brought on an ex parte basis. On the face of the notice, underneath applicant, but above the tram lines, insert for his/her, obviously delete whichever is not applicable, admission and enrollment as a legal practitioner of the High Court of South Africa. The prayers that the applicant be admitted as a legal practitioner of the High Court of South Africa, and that the above Honourable Court authorize that the applicant be enrolled as a legal practitioner on the roll that is kept by the Council in accordance with the provisions of Section 24, read with Section 30 of the Legal Practice Act 28 of 2014 as amended, and further and or alternative relief as the above Honourable Court may deem fit. Very important to those candidates undergoing articles for a period different to the standard 2 years, you'll need to include a prayer for condemnation before the prayer for admission as an attorney. The two most common types of condemnation are condoning non-compliance with the period specified in a contract of service or contract of articles of clerkship that was entered into for a period of 2 years and the applicant served only 1 year, but also attended the full-time practical legal training course for an uninterrupted period of at least 4 months. Secondly, condoning non-compliance with the period specified in a contract that was entered into for a period of 3/5 years. The applicant is at the time of the application still performing services in terms of the contract, and recognizing the period served prior to obtaining the BProc or LLB degree as regular service. As is the case with every application, you will reference the affidavits annexed. Both yourself and your principal will be deposing to affidavits. If you have previously seeded articles, your first principal will also depose to an affidavit. Although your admission application is done on an ex parte basis, it must be served on the LPC in terms of Rule 17. Service and other formalities of the admission application will be touched on later in this video. The reason why the above is mentioned here, in particular Rule 17.9, is because under the address of the LPC on the notice of motion, you'll insert the following to be formally acknowledged by the LPC. I acknowledge receipt of a copy of this application, together with copies of all supporting affidavits and all annexures thereto. I confirm that the prescribed fee, in terms of Rule 2.4 of the South African Legal Practice Council rules, has been paid, and I certify that proper notice of this application has been received in accordance with Rule 17 of the aforesaid rules. A link to a Google Drive folder containing a template for the notice of motion can be found in the description. Very important, it is just a rough template. The founding affidavit. As is the case with every notice of motion, there will be a founding affidavit attached to your application. According to Rule 17.2, an application for admission and enrollment in terms of Rule 17.1 must be in writing and must be accompanied by an affidavit by the applicant setting out the following information, supported, where applicable, by documentary evidence. Confirmation of jurisdiction of the court, his or her full names, date of birth, identity number, and residential address, confirmation that the applicant is a South African citizen or is a permanent resident of the Republic, confirmation that the applicant has satisfied all the requirements for a degree referred to in Section 26, subsection 1 of the Act, after pursuing for that degree a course of study referred to in that section. A statement whether the applicant intends to be enrolled and to practice as an attorney or as an advocate, or whether the applicant does not intend to practice. The physical address of his or her main office and of every branch office and of every building at and from which he or she practices, and his postal address and telephone numbers, mobile telephone numbers, fax numbers, email addresses, and other electronic communication contact particulars, if any. In the case of an attorney, whether he or she conducts practice for his or her own account, and if so, whether alone or in partnership, stating the full names of his or her partners, or as a member of a commercial juristic entity, stating the full names of his or her co-members, or as an employee. The name under which the firm of which he or she is a proprietor or a member, or by which he or she is employed, conducts practice. Confirmation that the applicant had no pecuniary interest in any law practice and that he or she held no other position than that of a candidate legal practitioner during the period of service under the contract of practical vocational training or supervision, or proof that the applicant had such pecuniary interest or held such other position with the prior written approval of the council. Confirmation that the applicant has undergone all the prescribed practical vocational training requirements as a candidate legal practitioner, referred to in Section 26, subsection 1c of the Act. Confirmation that the applicant has passed a competency-based examination or assessment for candidate legal practitioners, referred to in Section 26, subsection 1d. Take note, guys, that the original exam certificates will be handed to you on the day you uplift your application from the offices of the LPC for filing in the court file after the 1-month inspection period. You must, however, make provision in your founding affidavit and index for an annexure number for the certificates that consist of 4 pages. Take note further that the admission exams may only be written after you have undergone practical vocational training for a continuous period of not less than 6 months. Confirmation that the applicant has complied with the requirements for community service, if applicable, where that community service is a component of practical vocational training by candidate legal practitioners pursuant to the provisions of Section 29 of the Act, or proof that the applicant has been exempted from performing community service. Note that at the time of releasing this video, as far as we understand, no community service has been prescribed. If a period of more than 1 year has elapsed between the date of completion of the practical vocational training contract and the date of the application, a statement as to the activities of the applicant during that period. Confirmation that the applicant is a fit and proper person to be admitted, including a statement as to whether the applicant has any previous criminal convictions or has any criminal investigations pending, if there have been any proceedings as contemplated in the sub-rule, or if any such proceedings are pending, the applicant shall set out full details thereof. The applicant has been subjected to previous disciplinary proceedings by the council or any law society, university, or employer, or whether any such disciplinary proceedings are pending. If there have been any proceedings as contemplated in the sub-rule, or if any such proceedings are pending, the applicant shall set out full details thereof. The estate of the applicant has been sequestrated provisionally or finally, or whether there is any application for the sequestration of his or her estate which is pending. Where the estate of the applicant has been sequestrated, the applicant must state whether or not he or she has been rehabilitated. Confirmation that the originals of all attachments to the affidavit will be made available to the court on the date of the hearing of the application. Rule 17.3 provides that a person seeking to be admitted to practice and to be authorized to be enrolled as an attorney must include in the affidavit in support of the application, in addition to any other information to be provided in terms of this rule, confirmation that the applicant has served under a practical vocational training contract, stating the dates of filing and registration of that contract, and the period served by the applicant under that contract. Confirmation by the applicant that his or her principal was entitled to enter into the contract of practical vocational training. Confirmation by the applicant that service under the contract of practical vocational training was performed under the direct supervision of the principal or of another attorney in the firm of the principal. Confirmation that the applicant was not absent for more than 30 working days during any 1 year of service under the contract of practical vocational training. Confirmation by the applicant of the exact dates served under the practical vocational training contract. A statement as to the type of legal experience gained by the applicant while serving under the contract of practical vocational training. Rule 17.6 provides that copies of the following documents must be attached to the founding affidavit of the applicant and must be certified as being true copies of the originals by a notary public or by a commissioner of oaths. Identity document of the applicant. Where the surname of the applicant does not correspond with the applicant's name in the application or with any other documents attached to the application, a marriage certificate or other proof to reflect the reason for the discrepancy. Degree certificate or certificates of the applicant. The relevant practical vocational training contract. Written confirmation from the council confirming that the contract of practical vocational training has been registered with the council. Where applicable, an agreement relating to the cession of the contract of practical vocational training and written confirmation from the council that the cession of the contract has been registered. Attendance report issued in respect of attendance of the applicant at a practical legal training course approved by the council. Rule 17.4 states that an applicant for admission to practice and to be authorized to be enrolled as an attorney shall attach to his or her application a supporting affidavit by the applicant's principal containing the following information: confirmation of the exact dates that the applicant served under his or her supervision or that of another attorney in terms of the contract of practical vocational training, a statement that he or she has been practicing as an attorney for his or her own account or as a partner in a firm of attorneys or as a member of a professional company continuously for 3 years or for a period of 3 years in the aggregate during the preceding 4 years, or has practiced as a professional assistant in a firm for a period of 5 years within the preceding 6 years, or has practiced as a professional assistant in a firm for a period of 2 years in the preceding 5 years, and has practiced as an attorney for his or her own account, or as a partner in a firm or as a member of a professional company continuously for 2 years or for periods of 2 years in the aggregate during the preceding 4 years at the date of commencement of the contract of practical vocational training. Where the applicant has undergone practical vocational training with a law clinic or with Legal Aid South Africa or with another entity accredited by the council to provide practical vocational training, that his or her principal is, or at all relevant times was, in the full-time employment of the law clinic or of Legal Aid South Africa, or with such other entity, and has practiced as an attorney or advocate, as the case may be, continuously for 3 years, or for periods of 3 years in the aggregate during the preceding 4 years, prior to the date of commencement of the practical vocational training contract. Where the applicant has undergone practical vocational training with the state attorney, that his or her principal has practiced the profession of an attorney as the state attorney, deputy state attorney, senior assistant state attorney, or assistant state attorney in the office of the state attorney or any branch thereof, continuously for 4 years at the date of commencement of the practical vocational training contract. That he or she has continued to practice as aforesaid during the period of the contract of practical vocational training. That he or she was at no time during the course of the contract of the practical vocational training in question a principal to more than 3 candidate attorneys, or where the principal was employed at a law clinic or at Legal Aid South Africa, that he or she was at no time during the course of the contract of the practical vocational training in question a principal to more than 6 candidate attorneys. Confirmation that in his or her view the applicant is a fit and proper person to be admitted and enrolled as an attorney. Please note that your principal or principals may only sign the supporting affidavit once the period you are obliged to serve has been served. In addition to the notice of motion template, we have also placed in the Google Drive folder a template of the founding affidavit and principal supporting affidavit. Reminder, do not just rely on the templates. Make sure everything mentioned in the Legal Practice Act, its rules, and its regulations are complied with. Will my founding affidavit differ if I cede my articles? Yes, your founding affidavit will differ slightly where you ceded articles. Firstly, both your first principal and your current principal will need to depose to supporting affidavits. You'll need to add an additional subheading in your founding affidavit, for example, ceding of articles. Thereunder, you must state the following: the date you ceded articles, the firm to which you ceded articles, your new principal's name, the full details of the new firm, including inter alia, its physical address for each branch if there's more than one, as well as the contact details therefor, the date on which the cession of articles contract was lodged with the LPC, confirmation that the cession of articles contract was registered within 2 months of termination of the original articles contract, confirmation that your principal meets the criteria to take on a candidate legal practitioner as prescribed by the rules, the period under which you served your cession contract, confirmation that service with your principal was continuous and without interruption, confirmation that you are not absent for more than 30 working days per year, confirmation that you had no pecuniary interest in either firm. Additional annexes to your founding affidavit: the agreement relating to the cession of contract of practical vocational training and written confirmation from the council that the cession of the contract has been registered. A confirmatory/supporting affidavit of your second, which is your current, principal. An example of an admission application where the candidate ceded articles is linked in the Google Drive folder. The same disclaimer applies. What is the procedure after drafting the admission application? Issuing the application and obtaining a date. Once you have drafted your admission application and compiled the necessary annexes, you'll need to issue the application. Take note that this can only be done after your period of articles has been completed. Once your admission application has been issued, you will need to obtain a date for hearing. Those looking to be admitted in the Johannesburg or Pretoria High Court or any other court using case lines, you will need to apply for a date in accordance with the latest directives. Remember that your application has to lie with the LPC for 1 month, so make sure you give yourself enough time. In the video description, we have placed a link to the Gauteng Division's latest directives concerning admission. Follow these directives meticulously. Service of your admission application. Although your application will be heard on an ex parte basis, it has to be served on your provincial LPC office. Service usually needs to take place between 8 and 12:30, but this must be confirmed. Take note that you'll serve the application personally and not the sheriff. Before you serve your application on the LPC, you will need to do the following: index and paginate the application, make sufficient copies of the application, pay the prescribed fee, which is 460 Rand, VAT included as of 2021. Simultaneously with service of your application, you must lodge the enrollment form with the LPC as well. Rule 17.7 to 17.9 states that the original and 2 copies of the application must lie for inspection with the council for a period of not less than 1 month. The application must be properly prepared and bound with an index. All pages of the application must be paginated at the top right-hand corner of every page, and all attachments must be clearly marked when the application is served on the council. The council may require that the information referred to in this Rule 17 be submitted in a form to be determined by the council. An application in terms of this Rule 17 must be accompanied by proof of payment of the fee payable in terms of Rule 2. Feedback from the LPC. The LPC will either contact you and advise that amendments need to be made to your admission application or confirm that all is in order. If all is in order, you can collect your admission application and set it down for hearing on the allocated date. If amendments need to be made, same must be attended to ASAP so that the admission application can be returned to the LPC for confirmation that all is in order. Briefing counsel. Once your admission application is set down for hearing, you will need to brief counsel or an attorney with rights of appearance to move your admission on the allocated date. Take note that counsel usually does this without charge. What can I expect on the day my application is heard? When the Attorneys Act regulated admissions, the then Law Society would send admission guidelines. These guidelines are still mostly applicable today and include the following. Dress formal and conservative. Ensure the day before the hearing, at the latest, that all the originals of the annexes to your application are all together and ready for you to take to court. Your counsel or attorney must inform the court that he or she has seen the originals of the annexes and that they correspond with the copies annexed to the papers before the court. Occasionally, the court may require the originals to be handed up for inspection. If your admission is in Johannesburg or Pretoria, it will very likely take place virtually on MS Teams. Ensure you log on before 10. If your admission is taking place at court, arrive by no later than 9:15 on the day of hearing of the application, in order to ensure that you have sufficient time to meet with your counsel or attorney and ascertain in which court your application will be heard. Each matter will then be called by the judge's secretary. You must remain seated. When it is your matter, your counsel or attorney will address the court and the judge or judges may raise queries, and if not, order that you are admitted and that you may come forward to take the oath. If your admission is virtual, you will just turn your camera and mic on to take the oath. Once called forward, you will go to the front center of the bench to take the oath, not in the witness box, in front of the judge's secretary, who will inquire as to whether you have any objection to taking of the oath. Say no. The oath will then be read out and you will thereafter be requested to raise your right hand and say, "So help me God." For those being admitted online, you will just raise your hand on camera. Depending on the particular judge or judges, you may be congratulated immediately. Alternatively, you must stand aside to wait for all the applicants to first be admitted before being congratulated all at the same time. You may then take a seat on the benches on either the right side or the left side of the courtroom, and if there's no space or bench to be seated, line up standing against the wall. Once all the admissions on the roll have been called, the applicants will be requested to line up in front of the bench to be congratulated. You may thereafter leave the courtroom. For those online, you may be required to wait until everyone has been admitted, or you could potentially just have to excuse yourself and log off. The above is just a rough idea of what you can expect. Not every court will follow the same procedure. The court has granted my admission application. Now what? Section 30 subsection 1 and subsection 2 of the Legal Practice Act states that a person duly admitted by the High Court and authorized to be enrolled to practice as a legal practitioner must apply to the council in the manner determined in the rules for the enrollment of his or her name on the roll. The application referred to in paragraph A must be accompanied by the fee determined in the rules and indicate whether the applicant intends to practice as an attorney or an advocate, and in the case of an advocate, whether he or she intends practicing with or without a Fidelity Fund certificate, and be submitted to the council in the manner determined in the rules through the provincial council where the legal practitioner intends to practice. The council must enroll the applicant as an attorney, advocate, notary, or conveyancer, as the case may be, if he or she complies with the provisions of the Act. Section 30, subsection 5 states that the Registrar of the Division of the High Court, which makes an order admitting and authorizing a person to practice and be enrolled as a legal practitioner, must immediately, after the making of that order, forward a certified copy thereof to the council through the provincial council having jurisdiction. It is advisable to send the order to the council yourself as well. Once you have been enrolled, you will be able to see your details on the roll of practicing or non-practicing attorneys, whichever is applicable. Serving articles of clerkship during the transition from the Attorneys Act to the Legal Practice Act. There should be very few applicants still waiting admission who registered their contract of articles when the Attorneys Act was applicable. Should this be the case, you will need to make reference to both the Attorneys Act and the LPA in your papers. We will not go into depth here, but if you are one of those people, leave a comment and we will make a plan to get you a template. It is actually not uncommon that candidates often have to change their principal, in other words, finding alternative employment. This is known as seeding articles, and it can happen for a number of reasons. Let's look at the requirements and formalities involved therewith. What does it mean to seed articles? Simply put, to seed articles means changing your principal. In essence, you are terminating your employment with your initial firm and taking up employment at a different firm, hence the change in principle. The important distinction is that you do not restart articles, but rather continue with the service thereof just under a new principle. Cession usually occurs for a number of reasons, the most common being the following: extremely difficult principles, we've heard horror stories, unpleasant working environments, exploitative pay, better offers from other firms, lack of practical legal exposure, lack of learning on the job, death of a principal, insolvency of a principal's conviction of a crime, closure of a firm, and personal circumstances. There are a number of requirements to ceding articles, including the conclusion of a cession agreement, which we'll get into shortly. The parties to a cession agreement will be the cedant, who is your first principal, the cessionary, who is your new or your second principal, and the candidate legal practitioner, who is obviously you. When may articles be ceded? A practical vocational training contract, as we know by now, is an articles contract, may, with the consent of the principal and the candidate legal practitioner concerned, be ceded to any other principal willing to accept such cession. As mentioned earlier, your articles contract may be ceded for a number of reasons. What are the formalities pertaining to cession? As a candidate legal practitioner, the Legal Practice Council needs to know of your every move. Therefore, the following are requirements for the valid cession of your articles contract. A cession agreement must be concluded, the registration of the cession agreement fee must be paid, and a letter by the cessionary requesting the LPC to issue a certificate of right of appearance to you in accordance with Section 25, subsection 5A or subsection 5B of the Legal Practice Act, if applicable. These cession agreements. A cession agreement must be drawn up, and every page thereof must be signed by all three parties, namely the cedant, cessionary, and candidate. The agreement must also be signed by witnesses. The cession agreement must, within 2 months of the date on which the service of the candidate concerned may have terminated with the cedant, your first principal, or within such further period as the court may on good cause allow, be lodged with the Legal Practice Council by the cessionary, the second principal, together with affidavits, firstly by the cedant, stating whether the provisions of the Legal Practice Act and the rules relating to service under the Articles contract have been complied with during the whole term of service during which the candidate concerned was in the service of the cedant, and the date on which the candidate terminated their services with the cedant. And secondly, by the cessionary stating the date on which the candidate assumed duty with the cessionary. As per the aforementioned, if the cession agreement is not lodged within the 2 months period, the candidate legal practitioner will have to approach the court, which may allow the cession to be lodged with such further period on good cause shown. You don't want to place yourself in such a situation. A link to templates of the cession agreement, as well as the affidavits of the cedant and cessionary, can be found in the video description below. Payment of the registration fee. Prior to or simultaneously with the registration of the cession agreement, payment of the registration fee must be made to the LPC. The registration fee is, as of 2021, R345 VAT included. Payment can be made via EFT, so contact the LPC for the relevant bank details. We will not post them here. Take note of the reference to use when making payments. Should you make payment via EFT, proof thereof must be submitted together with the other cession documents. The request for a certificate of right of appearance. Your new principal must request the LPC to issue a certificate of right of appearance to you in accordance with Section 25, subsection 5A or subsection 5B of the Legal Practice Act, if applicable. The request must be in writing and can usually be emailed through to the LPC. This must, however, be confirmed with them. We have placed a template of the written request to be made by your principal in the Google Drive folder linked in the description. What happens once I've registered the cession agreement and lodged the supporting documents with the LPC? The LPC shall, on payment of such fee as may be prescribed, examine the agreement and the relevant affidavits, and if it is satisfied that the cession is in order and it has no objection thereto, register the session, and shall advise the attorney and the candidate concerned in writing of such registration. Session in the event of your principal's death, mental illness, insolvency, conviction of a crime, suspension from practice, striking off the roll, or discontinuation of practice. The LPC may, in the event of any of the aforementioned circumstances or any other cause, direct that the articles contract concerned be ceded to any other principal willing to accept such cession, and all service completed under the ceded contract shall be effective for purposes of the Legal Practice Act and its rules. The above is notwithstanding the fact that the principal who accepts the cession will, as a result of that acceptance, have more than the maximum allowable number of candidate attorneys in his or her employment. The agreement whereby the PVT contract is ceded shall be signed by the legal representative of the attorney concerned, or by the chairperson or the executive officer of the LPC as cedent, and a certificate of such legal representative, chairperson, or executive officer containing the relevant particulars shall serve as a substitute for the affidavit of the cedent referred to in the rules. If an articles contract is for any reason cancelled, abandoned, or ceded, the principal with whom the candidate legal practitioner is serving at that time must forthwith, in writing, notify the LPC of such cancellation, abandonment, or cession. So guys, that concludes everything pertaining to articles of clerkship. If you have any queries of whatsoever nature, just leave us a comment or catch us on our socials and send us a message. We are here to assist. So we hope that this has been a good experience and that you have much more insight into the profession after this. Stay tuned for many, many more episodes to come.